guys. Hey.
This is not your average podcast, trust me. This is IPSeries, where you learn to protect and safeguard all your intellectual property so you can make a career of what you love. Join me, Rita Chinda, as we discuss all things intellectual property from the world of fashion, film, media, entertainment, dispute resolution, and even technology. Welcome. Did you know that for a trademark to be registered, it must contain the required distinctiveness if it's able to distinguish a product or service based on the class registered? Now, why is this important? This is important because of our case study for today, where an alleged slang in Kenya was registered by a media personality and was later on used by a telecom company, one of the biggest telecom companies in Africa, Airtel Kenya, in their advert for their internet bundle. So it got me thinking. I mean, viral terms, slangs, or phrases can become popular, especially in this digital era where it can become like a generic term of some sort, widely used on the internet, often through social media platform. They can be considered as an intellectual property if they're original, creative, or are fixed in a tangible format, as we're looking at the copyright elements such as videos, blog posts, tweet. However, not all of these terms are eligible for IP protection, as some may be generic, descriptive, or be considered as a common expression that do not identify or specify a specific source to the author of this phrase. So why is this case important? When I first came across this case, what came to my mind was some of the viral terms that we've had in Nigeria so far, such as help me, my God, the top, LP, let the poor breathe. Then we also had one other famous one last year, Pressure Tiwa, that was used by an OAP in Nigeria. But then the reason why I kind of like connected two cases was the OAP and Mr. Willis Raburu are both media personalities. In the Kenya case, the media personality went ahead to register the trademark, and that gave him the right to prevent Airtel Kenya from actually using the phrase in their advert for their internet bundle. Whereas for the Nigerian case, no registration was done, nothing. So I'm looking at this case from three different angles. One, actual use and proposed use of a trademark. Two, can viral terms be protected as a trademark? And if yes, what are the criteria for registering viral terms or phrases or slogans or slangs, as the case may be, or as we have seen in this case, because the word Bazu is said to be a common slang in Kenya. And then finally, the use of phrases and terms, the applicability of such words or phrases in an advert. So that is what we will be discussing today. So on April 13th, 2021, Mr. Willis Ratburu um registered the word Bazu, which has a registration number 116744 under advertising, and telecom company. Now, shortly afterwards, Airtel Kenya used the word Bazu to promote one of their internet bundles without Mr. Willis Radborough's consent, permission, and authorization. And he went ahead to sue them sometime in June 2022. So apparently June 12th, 2022, and has now been um, ordered by the Milimari Commercial Chief Magistrate to pay Mr. Willis Raburu 6.5 million Kenyan shilling. And as a typical Nigerian girl, I had to do the math. 6.5 million Kenyan shilling is equals to 70,504,202 naira 99 kobo. That's a lot of money. Okay? And that was for the unauthorized use of the word Bazu. The court has further restrained them from using the trademark Bazu in publishing any of its material on broadcast media or using anything similar. Now, one interesting thing, or let's say it was funny reading, was finding out that Airtel's defense, their defense to using the word Bazu is um, Mr. Willis is looking for quick enrichment, and we had hoped for a silent treatment. I mean, seriously, is that even a type of dispute resolution mechanism? Just hearing that for the first time. But they went further to say that the term wasn't originally created by Willis, but that it was a well-known slang in local Shang language. So I finally got to the language part. And I was like, duh. But then it was also giving the whole Yoruba trademark dispute thingy. And I was like, okay, maybe I should look at this properly and give a non-biased view. Remember, I had talked about the Pressure Tiwa case. I mean, for us in Nigeria, we take slangs to be like our way of I think like comedy relief. So it just becomes a viral thing for a second and then we jump to the next one. Um but yeah, questions matters arising. Can an individual trademark a phrase or slang, and would it be considered for commercial purpose? Can it be trademarked for commercial purpose? Would it be considered to be generic? If it's an everyday common word used to depict something, yes. But if it meets the requirements under the Nigerian copyright, sorry, the Nigerian Trademark Act, oh my God, Section 9, 10, also the functions, it meets the requirement of what the function of the trademark is, I don't think we really have an issue. But there is a need. Is there really a need for us to protect slangs or viral terms and use it for commercial purpose? So remember, we're going to talk about types of trademark registration, where we'll look at actual use and purpose, um, purpose of use, and we'll take it up from there. So, what are the types of trademark application that we have? There is actual use, there's proposed to be used, and then there is trademark registration in connection in the course of trade. Now, what does that basically mean? Actual use application will be used by the trademark proprietor when they are currently using that trademark in commerce in relation to the goods or services that they offer. So, in this instance, now Willis Raburu's Bazu, he's already using the trademark for commercial purpose. He's already using it to make money, to make money basically in the telecom sector. You get, um, whereas for proposed to use application is that you have filed based on your intention to actually use Bazu as a trademark in that particular class. So therefore, it's also an application that um when it's filed by the applicant, they're not yet using the trademark, but they have plans to use the trademark in future. So Bazu for telecom in future. That is proposed to be used. Whereas actual use, you register using Bazu, you commence your application and all that. It also means that the actual use of a trademark is not really required before it can be accepted for registration. So if you can show that you have been using Bazu or any trademark, let's use IPSeries now, for commercial purpose, the right form of application will be actual use of the trademark, and you will be required to file it with proof. So I have to show proof that I've been using IPSeries or I've been using Bazu for commercial purpose at the time when I started filing the application. I also need to indicate the date um, that I say using the mark for commercial purpose. I hope that makes sense. Then for proposed use, another way you can look at it is that you're not using the mark, but you want to file your mark because you intend to use the mark for commercial purpose. And one of the benefits is that it gives you an opportunity as a business person to essentially reserve the name before you actually start using the trademark. So especially in instance where people want to start, you said a business name, register a business name at the Corporate Affairs Commission, and at this point in time, you may not really have the finance to bankroll your trademark registration. So that's going to be proposed to use for trademark in relation to whatever industry under the nice classification. I hope that makes sense. Then for the last one, which is a connection in the course of trade. Basically, what the courts or what we'll be looking at is that the use of Bazu or the use of IPSeries will be um, associated with the product or the goods, either in the course of their production or preparing to launch into the market. So if you make a trademark registration in relation to this, that the goods in the course of business are manufactured, then it will be considered to be a trademark application in connection in the course, a connection in the course of trade. I hope that that makes sense. I hope it does. So other than that, you also need to consider whether the mark you want to register is a registrable mark or on a mark that cannot be registrable. So what are the types of mark that you can actually register? You can register the name of a company or an individual, the signature, an invented word or words, any distinctive mark, any mark that is capable of becoming distinctive in use, and then you can also trademark any word that has no direct reference to the character or quality of goods, as the case may be, not being according to its ordinary significance or geographical name or surname. Whereas for marks that are not registrable, that means they are not accepted for registration at the trademark registry. It could be words that are likely to deceive or cause confusion, um, words that are contrary to any law at the time being in force, any mark comprising or containing scandalous or obscene matters, any trademark that is contrary to public policy and not acceptable to morality, um, any mark that is likely to hurt um, the religious susceptibilities of any class or section. For instance, would be the names of holy book. It also includes trademarking the name of God. You get. I think this also reminds me of the Lil Nas Satan shoe case. Though it wasn't trademark, but Mischief and Lil Nas had gone into a partnership to create a 666 a Satan shoe collection, and the religious people were not having it. So something like that. Then any mark that is identical or deceptively similar to an existing trademark, a geographical name or surname or a personal name or common law or any common abbreviation or the name of a sect, a caste, a tribe in Nigeria, hence Yoruba trademark, hence Omotala. That Omotala one was really, really fierce. Any mark which will be disentitled to protection in the court of law. Um, for reference, in Section 11, Paragraph A of the Nigerian Trademark Act. And finally, registering any single chemical name or chemical compound. So these are the things that you need to take into consideration, the type of registration you want to do, actual use, proposed use, a connection and use of trade, whether it's a registrable mark or non-registrable mark. So that's it for this phase. Another interesting thing that one may consider when it comes to trademark is the fact that a trademark may also have a secondary meaning, and it would be best for the intending proprietor to build and protect a strong brand along with having a brand management to help protect and monitor it from any form of infringement. So, what is um, a likely scenario when it comes to trademark protection in Kenya? What I found out again is that the Kenya trademark law is kind of similar to the Nigerian trademark law, but here are some relevant provisions if you're going to be having dealings in Kenya, and also I'll be related to our case study for today. For instance, Section 4 provides that where a trademark is registered in respect of a particular good or classes of goods, any question or that will lie any question on that will lie with the registrar, whose decision will be final. So it goes that the register is divided into part A and part B, which is similar to Nigeria, and the register shall be kept under the control and management of the registrar, and shall at all convenience and be open to the inspection of the public. We do not have this provision in Nigeria, but like I said, there are certain sections that are similar to ours. Then you have Section 7, which talks about the rights given by registration in Part A and then infringement thereof. So basically, it's saying that Section 10 and 11, the registration done either before or after January 1957. Remember, this one was done 2021. So any registration done under this part gives Mr. Willis Raburu the exclusive right to the use of the trademark in relation to the goods in which is now in as a telecom service, and without prejudice to the generality of the foregoing, that right is infringed by any person not being anybody who infringes the right not being the proprietor, which in this case is Airtel Kenya, of the mark using by way of permitted use uses a mark identical with or so nearly resembling it as to be likely to deceive or cause confusion in the course of trade or in connection with the provision of any service. So I think I'm going to add that one, that's in connection with the provision of any services, as the fourth type of trademark registration. And in such a manner render the use of the mark likely to be taken either as being used as a trademark or to be taken in a case which the use is upon the goods or in physical relation or in an advertising circular, or other advertisement issued to the public as importing a reference to some person having the right either as proprietor or as licensee to use the trademark or goods which such person is connected in the course of trade. So remember, this case basically is why we have this is because Airtel Kenya used Bazu in an advertising circular for the internet bundle, and again, the advertisement was issued to the public, it was published. Does that sound right? Yeah. So the publication was made to the general public and everyone saw and was like, oh, okay. Bazu, internet bundle, blah, blah, blah. You get what I mean? And then there's another scenario. So we don't have this particular one, but like I said,
we have registration for part A, part B, and then there's a differentiation or clarity as to that. If again, so going for it talks about whether the use will cause injury or prejudice to the trademark proprietor or licensee. Airtel Kenya is not a licensee. A licensee is basically someone who Mr. Raburu has given the right to use Bazu. So it goes into a licensing agreement, an exclusive or non-exclusive licensing agreement with Mr. Bazu to use with Mr. Raburu to use Bazu. Um and then there's a case where the use is used at or near the place where the services are available for acceptance or performed or in an advertising circle. I like the fact that the Kenyan law, keeps making emphasis on advertising, and kind of like it blew my mind reading this. Then sub 2 says the right to use a mark given by registration shall be subject to any condition or limitation entered on the register and shall not be deemed to have been infringed by the use of such mark in any mode. It talks about the right of the use of a trademark given by registration shall not be deemed to be infringed by the use of such by any person in relation to goods connected in course of trade with the proprietor or licensee, in relation to the goods adapted to form part or to be accessory to, in relation to services, the provisions of which is connected in the course of business, in relation to services available for use with other services, and it goes on and on. So if you have the time, please read section 7 of the Kenya Trademark Act. Whereas after that section, you just went right into infringement by breach of certain restriction. That is for section 9. Then which basically talks about whereby a contract in writing makes with the proprietor or licensee. There was no contract between Airtel Kenya and Mr. Willis to use the slang or the word Bazu for the advertising purpose. So, whereby a contract in writing made by the proprietor or the licensee registered and a purchaser or owner of the goods or person performing the services enter into an obligation to the effect that he will not do in relation to the goods or services any act that is meant for the owner, either by performing the service or having notice of the obligation. The act which applies to the application of the trademark upon the goods. In case where the trademark is upon the goods, the alteration, part removal, or part obliteration, or in the case where the trademark is upon the goods, there's also other matter being matters indicating a connection in the course of trade, where the trademark is used upon the goods, the application of any trademark to the goods, and then it goes further in sub 3 to say in this section, references in relation to any goods to the proprietor, to the registered user, and to the registration of a trademark shall be construed, respectively, as references to the proprietor in whose name the trademark is registered. So, after reading section 7 and 9, would you agree with me that Bazu has been adapted to distinguish and has acquired substantial goodwill over time? Other than the fact that Mr. Raburu registered the mark, I don't think there was any documentation to show that he had been using Bazu for commercial purpose. But then that's the beauty of trademark. Trademark gives you the power to prevent other people from commercially exploiting your registered trademark, because the trademark, especially in regards to the telecom services that Willis Raburu use, is exclusive to him. So the doctrine of distinctiveness under the Kenyan law is actually slightly different from the Nigerian version, but we see that the law is trying to ensure that the proprietor's rights are actually covered and no one is actually taking advantage of any lacuna or gaps within the trademark law. And also the fact that the registry is open to the public. So when you're doing a registration at the Kenya Industrial Property Institute, you can go to there to make further inquiries about a particular registration. So if you want more details about this, or if you have further questions, you can reach out to a Kenya trademark lawyer, or if you want me to do the research for you, answer questions, I'm here as always. So we're also going to look at section 46 of the Kenya Trademark Act, which talks about registration being a prima facie evidence for all validity. We're also going to be looking at section 54A, which talks about the nice agreement receivable in evidence. Section 58 talks about fine for falsely representing a trademark as registered. And then there's 58G, which talks about evidence. So these provisions will focus on legal proceedings and appeal, offences and restraints of registration and use of certain marks within Kenya. So let's start off with, I think I should check out section 22 first. I'm thinking 12 to 20 to 18 first. So 12 basically talks about distinctiveness requirement for registration in Part A. So the distinctiveness requirement will consist of at least one of the following: the name of the company, individual or firm, signature of the applicant, an invented words, a word having direct reference to the character or any distinctive mark, but the name, signature, or word or words other than such within the description. So it goes further to define distinctiveness to mean adapted in relation to the goods in respect of which a trademark is registered or proposed to be registered. See the type of trademark application. To distinguish goods with the proprietor of a trademark or may be connected in the course of trade, another type, from the goods in the case of which no such connection subsists either generally or where the trademark is registered or proposed to be registered, subject to limitations in relation to use within the extent of the registration. So whatever registration you're doing has to be within what you have registered, the purpose for which you've registered. Also, in determining whether a trademark is adapted to distinguish, the court of registrar may have regard to the extent to which the trademark is adapted to distinguish, and by reason of the use of the trademark or any other circumstances, the trademark is in fact adapted to distinguish. And I think Raburu met all these requirements, hence why his application was granted to him on the 13th day of April. Now, section 13 talks about capability of distinguishing requisite for registration in part B. We have capable of distinguishing, and we also have distinctiveness provision under 9 and 10, yeah, of the Nigerian Trademark Act. Then you also have provision of registration of deceptive matter. I don't think that applies here because Airtel did not attempt to register but only attempted to take advantage of a registered trademark being used for advertising purpose. Prohibition of registration of identical and similar trademark not applicable here as well. Protection of well-known mark. Yeah, so another area that we may consider is, so because Bazu is according to Airtel is a popular Slang language in Kenya. I do not know, or I'm not, yeah, let me rephrase it. I do not think that Bazu will qualify as a well-known trademark because under the law, what a well-known trademark means is that it is entitled to the protection of the Paris Convention or the WTO as a World Trade Organization agreement as a well-known mark, and it must be well known in Kenya as being the mark of a person who is a national. So Rabu is a national. He's domiciled in Kenya and is also subject to Section 38B that the proprietor is entitled to protection under the Paris Convention as well as or the WTO agreement as well as a well-known trademark and is entitled to restrained by injunction. So remember in this case that the court restrained Airtel from further making any publication about the Bazu internet bundle, which is identical, or the essential part which is identical or similar to his in relation to, or identical or similar goods or services. Forgive me. Goes further to say shall have shall affect the continuation of any bona fide use of a trademark begun before commencement of this section. A trademark shall not be registered if the trademark or an essential part is likely to impair, interfere with, or take undue advantage of the distinctive character of the well-known trademark. So because Bazu wasn't a trademark, I think this will not apply, but then that gives you an idea of how the Kenyan trademark law has envisioned certain things that may happen that might happen in the future. And there's registration to be um imparted to be conclusive as to be valid after 7 years. Registration subject to disclaimer. This will occur where it contains any parts not separately registered by the proprietor, contains matter common to the trade or the provision of the services. So there is the duty of the registrar of the court to decide whether that trademark shall be entered or shall remain on the register and may require as a condition of it to be registered. Now let's move to 22. Okay, 18 before 20. So words used as name or description of an article or substance. Okay. Because there's no color conversation here, I'm going to skip that. 22 talks about, hold on, registration proper. So when an application for registration is in part A or part B, the red of the register has been accepted, or either the application has not been opposed and the time for notice of opposition has expired, or the application has been opposed and the application and the opposition has been decided in favor of the applicant. The registrar shall, unless the application has been accepted in error, register that trademark. Provided that the provision of this section relating to the date as when the rest of registered to the date deemed to be, they shall, as respect under this act, benefits with the benefit of the enactment relating to the international or inter-imperial arrangement have effect. On registration of trademark, the registrar shall issue to the applicant a certificate which Mr. Raburu has the trademark number to be 116744. So he has proof of that already. So Airtel has nothing, and coming to say that Raburu is just looking for quick enrichment wasn't nice. I mean, come on, guys, you guys can do better than that. You are a multinational, you know. So let's go over to section 54. This is a long read. Anyways, section 54. Yeah, give me a sec. 54A talks about the nice agreement. So the nice agreement basically guides trademark proprietors, agents, applicants on the registration of trademark. And I think the most recent one is the 2022 version. You can Google that, the nice agreement concerning the international classification of goods and services for the purpose of registration of trademark. Okay. It's all revision together with the publications of the World Intellectual Property Organization of Geneva relating to the agreement may be received in evidence before any court or registrar and shall take into account by the registrar in relation to duty under this act. So Rabu already has that evidence that he used the nice classification to register his mark, hence why the registrar gave him an application or a certificate post application. And in all of this conversation, we've never heard Airtel Kenya. I almost said Airtel Nigeria. Airtel Kenya never said that they own the mark, but rather, let's look at section 49 of the Nigerian Trademark Act, which talks about legal proceedings and appeal. So registration to be prima facie evidence of validity, and there's a similar provision in Kenya. So under the Nigerian, it says in all legal proceedings related to a registered trademark, including applications under section 38. What's 30? 38, 38, 38. Hold on. 38, I think 38 is for ratification. Yes, to ratify or make a correction in the registry. That a person is registered as a proprietor shall be the prima facie evidence, that's the necessary evidence needed to show proof that that is the original registration of the trademark and of all subsequent assignments and transmission thereof. Let's look at what the Kenya provision is. That's 58. No, 50. Yeah, 58, but 58 G. So there's a part, B part, C, D, and yeah, evidence. So any invoice or other document submitted or used by importer or any person in connection with importation of the goods in respect of the person, with importation for prosecution of the bottom of this part, for criminal proceeding without calling the person who prepared or signed it. In any prosecution for an offense under this part, evidence are any imported. So basically, under 5G, just talking about evidence. But I'm looking for the Nigerian interpretation. Please forgive me if you're listening to me. Can't seem to reach it right now. 46. Varied. Registration as proof of validity is 46 for Kenya and 49 for Nigeria. Then you also have the duties of the court under section 49 for Nigeria. Still, duty of the court for Nigeria. And then section 7, which grants the proprietor of a registered mark, which in this case is Willis Raburu, the right to interfere with or restrain Airtel Kenya's use of identical or nearly resembling Bazu in relation to the telecom service, and may be used as a defense in a trademark action. So what amounts to a trademark infringement action in Nigeria and not so in Kenya? Now, in Kenya, Section 5 provides that no person shall be entitled. You cannot file a lawsuit or try to recover damage for infringement of an unregistered mark. Unregistered trademark will rather give you a limited protection for passing off, and you also do not have right of action against any person for passing off, or there are no available remedies such as recovery of damages. Whereas if you have a registered trademark like Mr. Willis Raburu, you can sue for trademark infringement. You see that Willis Raburu has been awarded 6.5 million Kenyan shilling. Also, the courts issued an injunction restraining Airtel Kenya from further publishing anything that has to do with the use of the word Bazu for promoting the product, because it's likely to deceive or cause confusion. See also section 11 and 13 of the Nigerian Trademark Acts, which talks about what can be read, what cannot be registered. I remember I mentioned that when I was discussing registrable and non-registrable. So deceptive or scandalous matter, and then identical or similar mark. Which is why it is important for a prospective trademark applicant to carry out an exhaustive research. I say research, an exhaustive search at the trademark registry to confirm that there are no identical or confusingly similar marks, or that there is no existing unregistered well-known mark that is also identical or confusingly similar to the prospective mark. In all of this, Airtel Kenya still did not do any registration. No, there was no registration at all to show that okay, we actually registered and that's why we're using it. But they just went ahead and say, oh, because it's a popular Shang language, I can use it. But then again, I think there's this thing. I think people are usually attracted when someone tries to monetize something. Everyone just gets interested, like, oh, why is this person monetizing it? I should get a piece of it. He's not entitled to it. No, that's not how trademark works. For the Kenya, read also section 9 talks about infringement by breach of certain restrictions. Well, yeah. Then there is section 31, which makes provision for registered users. So it says, sub 3 says that subject to any agreement substituting with the party, a licensee of a trademark shall be entitled to call upon the proprietor to take proceedings to prevent infringement, and if the proprietor refuses or neglects to do so within 2 months after make call, the licensee may institute proceeding for infringement in his own name as if he were the proprietor, making the proprietor a defendant, and a proprietor so added as defendant shall not be liable for any cost unless he enters appearance and takes part in. I think I'm really says I'm stressing it. I'm really loving the Kenyan Trademark Act. Like, the more I read it, the more intriguing it gets. There's also provision for certification mark, but this is not a certification case, so I'm not going to delve into that conversation. So for permitted use, what are you allowed to do under the Kenya Act or Kenya Trademark Law? If you own a trademark, see section 31. I think I read it for you guys, but let's see. No, I'm kind of confusing it though. Section 31. What I'm seeing here. Hold on. Okay, I was looking at the trademark rules. Heart attack. Okay, so section 31 of the Trademark Act talks about permitted use as provided under the Act. So, registered users of X, while for Nigeria, defensive registration of a well-known inverted mark under section 32, and there was a set of a registered user is under section 33, which states that the use of a trademark by registered user in relation to a good for which is connected in trace or registered of which for the time being the mark remains registered, he is registered. He may be registered as the registered user of the mark. But you need to know that any unauthorized use will amount to an infringement, whether under Kenyan law or Nigerian law. So, what are the possible defenses to an infringement claim? One, consent delay or acquiescence, right to independent use, no likelihood of deception, and also non-registration or invalidity of a registration of the trademark. There's also non-use. Okay, so you can claim non-use, and there's a process for that where you apply for the mark to be cancelled and all of this. And so talk to a trademark lawyer within your jurisdiction to find out what are the likely trademark defenses as provided under the law, and then don't accuse someone that is enforcing his right. They are looking for a quicker way or cheap way, a faster way to make money. Challenges of using a viral term or phrase or word is that you may run into infringement claims, especially when you've not gotten consent. You may also violate the laws or norms of decency, morality, religion, or offend or harm a certain group of individual. Um, they may also confuse or mislead the consumers. Sometimes too, they they can distort the culture and language, and also undermine the preservation and promotion of an identity of a particular um, place or culture or group of persons. So, in all of this conversation today, um, you need to know that you need to be aware of the challenges and limitations in protecting such. You need to understand the concept of proving your ownership on originality. Remember, Airtel Kenya accused um, Willis Raburu of not being the original creator of the Bazu word. You need to also consider balancing your rights and interests with public interest and looking at freedom of expression. You may also face difficulty in enforcing your rights and remedies against infringers, especially in this online and social media era where infringers may be anonymous, unreachable, or unresponsive. You may incur costs in the process of trying to take legal actions against such persons at the end of the day. There's opportunity for you to create content, license, and then also ensure that you are seen as a credible person, So, yeah. And so we've come to the end of this episode. I hope you learned something new about this case. What do you think? Do you agree or disagree um, with intellectual property protection for viral terms, slang? Share your thoughts and opinion with me. For trademark owners, you're expected to be vigilant about prospective marks being published by the Trademark Registry in the Trademark Journal. So if you're in Kenya or Nigeria, please make your inquiries. Also, for intending users of a mark, it is important, very important, that you obtain consent, permission, and authorization before using anybody's registered trademark. Okay, so closing with that. Thank you for listening to IP Series Podcast. If you enjoyed this episode, please subscribe, rate, and review us on your favorite podcast platform. Don't forget to share it with your friends, family, and colleagues. You can also follow us on Instagram at IPSeries with Esmeraldo ESQ, or Twitter at IPSeries1, or send us an email to ipseriesinfo@gmail.com. Until next time, stay tuned and stay informed.